What's up, everybody? It's Jason Cruz here once again with another episode of the Legal Submission. And in this episode, we are going to give you a quick update on what's going on with the UFC Antitrust lawsuit. As we recall, back in December, Judge Richard Boulware decided that he was going to issue order for class certification for the bout class of the plaintiffs that have filed the lawsuit against UFC. He inferred that he was also going to deny the request for class certification for identity class individuals, people who might have been affected by the loss of rights regarding their likeness in UFC materials. Well, that happened in December, and we all thought that an opinion was going to be issued sometime right after the hearing. But Christmas went by, New Year's went by, and here we are. We're recording this. I'm recording this on January 28th, and we still have no opinion. So this might be the result of a minute order that was filed on January 6th by the court, which indicated that it would be issuing a release of the sealed documents in the UFC antitrust lawsuit. What that means is that in addition to the issuance of the opinion, the court would also release all documents that the plaintiffs and the defendants and any third parties had provided them for this lawsuit that were filed to the court, and they would be released to the public. Well, there was an outpouring by media, fans, and third parties about what to do with that. So now the media and fans obviously were in support of releasing the documents as the court had indicated it might be doing. Bellator, which is a non-party to this lawsuit but had to provide documents under a subpoena, indicated that they wanted some of the documents they provided to be still under seal, to be held back from public consumption, because they argued that they had trade secrets, financial information, business secrets, things of that nature in those documents, and they had provided them to the court because they had to. They had a legal requirement to, under a subpoena, under the request from either the plaintiffs or Zuffa to provide those documents. The court told Bellator they had to, but Bellator is now coming back and saying, hey, wait a second now, we were going to give you the documents, but we didn't say the public could see them. So the judge is taking that under advisement as he contemplates what to do in balancing the request from the public to release the documents versus the potential issue related to its trade secrets on part of Bellator. Whether those are real trade secrets or not, or whether Bellator just wants to withhold that information so that third parties, such as competitors like the UFC or maybe any other promotion out there, won't be privy to them. You know, obviously there are things related to maybe finances, how it signs athletes, things of that nature, which perhaps Bellator does not want to have out there. So the other question that is going to come up is, what's going on with the documents that have been redacted? Sure, you're going to release the documents, but are you going to release the redacted documents? A lot of these filings had redactions in which you couldn't read or determine what was going on in the filings. Certainly, based on educated guesses, you could kind of tell what was going on in the documents, but once again, for whatever reason, they believed that the redactions, the blocks that you see in legal filings, were warranted, and if the court so sees fit, would they unredact those documents? My guess is that they probably will not, simply because that undertaking takes a long, is arduous, costly process. So I'm not sure if we, even if they were to release all these documents, that they would unredact this information. Perhaps they will. I could be wrong. However, one of the things that will be argued probably by Zuffa and maybe Bellator as well is that private information such as addresses, tax records, information related to perhaps any social security information or an individual's health. Those things probably should still be kept under a block or under a seal or under some sort of protective order in which you cannot release those things. As plaintiffs will see this as a stalling tactic, even though it probably isn't, because it's a relevant and salient point. But still, you could see plaintiff arguing that, hey, you can make the order, and if they need to petition for review, they can petition for review. And if there is any other issues, they could file anything under seal that they put for any document that they cite. Plaintiffs will argue that they don't have to include any confidential information in a petition for review, or they would also argue that any of the documents that are held confidential, they know which ones would be potential to be held by the court, and so the court wouldn't have to make a necessary determination on that. So where does that leave us? It's January 28th now, three or 4 weeks after the court said it was going to release documents with a order from the court issuing a class certification. What is going on? Well, plaintiffs in the lawsuit obviously are antsy to find out what the determination is, especially since the judge said that they were granting class cert for the bout class, the biggest class that they were requesting. So it had originally objected to Bellator's request for keeping certain documents sealed. However, in a recent filing of earlier this week, it said that they could go ahead and keep those filings under seal, in addition to the fact that they proposed that the court release the order, the class certification order, and leave for another day what to do with the documents that were proposed to be released at the same time. So basically saying, hey, bring out the class certification order so we could start litigating the process. As far as holding or withholding the documents, let's leave that for another time, or brief that later on so there can be a determination at a later point. But let's not hold up this order, because we're kind of determining a ancillary issue. Now, Zuffa obviously is taking a different tack. It's saying, whoa, wait a second now. let's hold the order at this point and determine what's going on with respect to the release of these documents. They indicate, kind of tipping their hand, but maybe not so much, because we all knew that they would be appealing the decision of granting class certification to the bout class, and saying that in addition to the 14-day window, once the documents, once the order is issued, they have 14 days to issue an appeal, which they have basically said they're going to do. They're also claiming that if they release the records at the same time, then they're going to have to they're going to have to be briefed on that too. So there'll be dual work happening at the same time. Or as plaintiffs note that if they keep the so as Zuffa has already noted in its objections to the release of the documents, it's also saying that the proposal by plaintiffs, which would push back any order on the unsealing of documents, would create a duplicitous work for the Zuffa attorneys, meaning that not only would they have to hurry up and come up with the appeal within 14 days of the issuance, they would also have to deal with the unsealing of documents and briefing on that matter, because it's based on their filings. Zuffa doesn't want certain documents to get out there to third parties and the public and the media. Certainly there's things that they probably foresee in there that can be picked apart by media types. There could also be information that can be utilized by third parties, similar like to how Bellator is arguing that certain documents not be made public. The UFC is in turn saying, hey, we don't want some of our documents to be put in public too, because it reveals things such as finances and other trade secrets. So what is going to happen? It certainly, if you're someone following this, and if you're watching this, you probably are following this, certainly the judge should probably at some point make a decision. Now, New York Times in early January provided a letter which indicated very detailed points as to why the public and the media should have access to the records that are being currently held under seal. The judge will have to balance those with the right to hold those documents on the part of Zuffa. You know, there are certain exceptions to revealing these types of documents. And of course, you know, issuing the class cert order. We already know what's in the order, but we need to know what's in the order. And what I mean by that is that both plaintiffs and Zuffa want to know the rationale for either granting or denying class certification. The reason why is that from there they can go forward and notify the Ninth Circuit of their appeal, as well as just getting it ready and getting briefed upon it, starting to make up a case for why the court should be overturned for either granting or denying class cert. So hopefully we'll get something in the month of February, as we're already at the end of January. We will continue to follow this. If you haven't already, I have a newsletter out for the legal submission. Go ahead, it's free. Go to MMA Payout. If you're watching this on YouTube, go ahead and subscribe to the channel. It'll be great. This is Jason Cruz for the legal submission. Have a great one.